Hi, I'm Derek Fahey. I'm a registered patent attorney and intellectual property attorney with the Plus IP firm. And this is going to be a brief video on the recent class action lawsuit that was filed against Meta Platforms, or Meta, that was formerly known as Facebook, because of its Llama model, language model, that uses artificial intelligence to generate content. The lawsuit was filed by Sarah Silverman and other famous novelists. And essentially what the lawsuit is all about is Facebook, or Meta's use of the content that was copyrighted to train its language models. How this typically works is Meta has to take information to use as a training set to train its language models for us to be able to prompt the language model to be able to generate content. And what the complaint alleges, that was filed in district court in California, is that Meta actually allegedly copied the information from Sarah Silverman and other novelists to train its language models. Essentially what it would have to do is it would go to these quote-unquote shadow libraries that had books that were illegal copies of these books, take that information that was copied and put that information into its language model, to be able to train the language model in order to generate the content when prompted. So the complaint alleges that it copies the information and it engineers the language model to generate new content based upon this information that was copied. Now, the plaintiffs in this particular lawsuit had several causes of action. The first cause of action is good old-fashioned copyright infringement. You copied our information without our permission to put that information into your language model, and it's actually inside of the language model that you use to train your language model so that when prompted, it can generate new matter. Copyright infringement. The second thing that it also alleged is vicarious infringement. So essentially they're saying that, well, because you are creating new content from our original content, that expressive content is actually you're vicariously copying, or almost like copyright infringement inducement. So that's the second cause of action. They also had some other causes of action that are also interesting and also pretty good arguments, quite honestly. So the first one they also have is unjust enrichment. So essentially you have this information that you copied, and even if you didn't copy it, you're unjustifiably benefiting and being enriched by the use of our content that we created in order to generate new content. So you're generating profits based upon us, and you're unjustly enriching yourself because of our content. They also have unfair competition that basically argues you did something bad, you copied some content from us, and now you're benefiting from us, which is not good, and it's unfair competition. It's unfair to us, and we should be compensated for it. They also alleged, the plaintiffs in this particular lawsuit also alleged that by actually taking the content from the shadow libraries that illegally copied, the information, when they put it into the language model, they had to remove the copyrighted information that you typically give for copyrighted material, like the name of the author or the owner of the rights, the copyrighted symbol. So it's copyrighted symbol, which is technically is actually a violation under the copyright statutes. And because of that, they filed basically a cause of action for saying that Meta illegally removed the copyrighted information from the content that they copied. So those are the causes of action that were alleged in this lawsuit against Meta Platforms. I find it really interesting because we know that in the future this is going to happen time and time and over again. Until the people or the models that are trained on things that are licensed from other people, we're going to keep on seeing these lawsuits. In particular, I recently heard a podcast, I think it was Bloomberg, where I think it was the CFO of Adobe actually came on and said they were not concerned about it because all of the training models that they used to train their models, actually they had license for. So they actually proactively went out and acquired licenses for this information. So I find it really interesting. This is going to be an interesting case moving forward. I'm sure a lot of people are going to be watching it, and I'm really curious to see what happens to this My guess is it may settle for some sort of fee based upon the use of it, so that how all of the class action plaintiffs can get some sort of fee for it. But really interesting, because copyright infringement actually has statutory damages and attorney's fees and cost provisions, so that how the attorneys have a benefit for it, which gives actually a leverage to the plaintiffs. So really interesting. If you have any questions, please reach out to me. My name is Derek Fahey. I'm a registered patent attorney and intellectual property attorney with the Plus IP firm. You can find me in all the socials. My Instagram handle is Derek Fahey PA, DerekFaheyPA. TikTok, Derek Fahey PA. My YouTube channel is Derek Fahey Esquire ESQ. Please leave your comments. If you like this video, please subscribe, like me, do all the stuff that really helps me spread the word. Looking forward to seeing you again soon. Have a great day.